Hi, everybody. This is Kara with Senior and Disability Services, and we're glad you're here today for our webinar about guardianship and POA documents and what we're looking for, what SDS is looking for within those documents. Sorry to have a little bit of a late start, but we did have a couple of technical difficulties. No worries, we are here for you. We'll have a presentation and then time for Q&A. So let me go ahead and share my screen. And as always, go ahead and fill in your questions into the question or chat area. You should be able to see that on your taskbar or control bar. Most of us here today are care coordinators or perhaps some SDS staffers. Just go for it as we move along. We do have a couple of handouts for you in the handout section. If you're able to download those, go for it. If you can't download them just because you're on a device that doesn't allow downloading of these types of files, no worries. We'll email them to you after the presentation. Just give us a little bit of time to get that ready for you. You'll get a link to a certificate download about an hour after the webinar ends. So make sure to check the email that you registered by to get your link to download a certificate of attendance. If for some reason you're unable to download your certificate, please just email us at sdstraining@alaska.gov and we'll take care of you. Make sure that you get your credit for 1 hour CEH for this presentation. All right. So I'm going to quickly check my questions here and just see that folks are having a good experience so far, so good. Okay, awesome. And we'll start our presentation. By the way, our handouts do consist of the PowerPoint that you're going to watch, or it's actually, relatively short. There's a booklet in there, and there is a reference document for you to go by that has a little bit more details than the sort of summary that we're doing on the PowerPoint today. Okay, so let me do my slideshow real quick. Okay, guardianship and POA documents. What is SDS looking for? This webinar is good for you if you help collect documents like this on the behalf of individuals and families. If you're a care coordinator or maybe somebody who reviews the packet, these are just some basics to know. I did want to give a shout out to our content development team for this. Lots of people worked on this and put it together. So the result of the work product that you see here was a group effort and a vetting system as well. So we have Kimberlina Lopez, Kat Sauer-Lipinskas, Paul Peterson, Rodney George, Jetta Whitaker, Heather Cord, and of course your SDS training team, who are also with me here, Delight Mells and Cassandra Lynch, and Kat is with us as well, the care coordinator liaison. So I just wanted to thank everybody for making wonderful materials and making it easy to present a somewhat complicated topic. So thank you to the whole team. After this presentation, you should be able to state the main difference between guardianship and power of attorney. And for SDS accepted documents, you should be able to identify the kinds of decisions a power of attorney document must have on it, a list. You should be able to state one action you can take if you're in doubt about a person's legal document. Okay, so for today, we're going to talk about these topics: legal guardianship, power of attorney, surrogate decision making or maker, legal representation of a minor, and name change And we have some other information that will be helpful for you as well. Okay, regarding legal guardianship, what is SDS looking for? Legal guardianship is unique because it's assigned by the court. Okay, so a family, or otherwise known as probate court, a judge has decided that this person is going to have a guardian. The guardian is appointed by the court, and the guardian, you'll see this in the documents, they make healthcare and other non-financial decisions. They can make financial decisions if they're also appointed conservator. A conservator ensures that the person's benefits and any other income they have is tracked and spent for the person. And there's an annual report that is due for all of the folks that are identified in the document. There can be a single guardian, and there could possibly be more than one guardian, and they might do different things, and that is what the judge will describe in the document. That it will be written in the document. The person will have an expert review of their medical needs and conditions and capacity. So there's a panel of folks that the medical expert and a court visitor, they'll put all this information together for the judge so the judge can determine. And when it comes to guardianship, the judge has determined that the person cannot act on their own behalf permanently because of illness or disability. And that guardianship document will define the guardian or guardian's duties. So what about those documents? What is SDS looking for? The guardianship document, the applicant is the ward on the document. Okay, so it has to be, when we say applicant, I'm talking about somebody a care coordinator would help by filling out an application, or in some cases a reapplication. I'm just going to call it the same thing. So the person who's applying is the ward on the document. That's all that means. The guardian on the SDS application form is the same as on the guardianship decree. Okay? And the documents that could be turned in might say letter of guardianship or appointment of guardianship on them. They may have titles like that. They're typical titles. And it will list the duties. And you'll find these details in findings and order of guardianship, typically. It's a top title on the document, or it might say guardianship plan. Okay? So you've got the players, the people we're talking about on that document, and then the actual duties. Okay, so what's required is that we need to receive the whole document, including all pages, and it needs to be signed and dated by the superior court or magistrate. You'll usually see that there's a seal or something like that too. Right, so knowing that guardianship is a process, it takes time to get the whole final document, and many times people are given a copy of the draft or other documents that you might get prior to actual guardianship, a final guardianship. What we're looking for is the signature and or the seal, which contains a signature. They always sign it too. And that says that it's the final one. Okay? So that's what I'm trying to explain here. Sometimes the guardianship case has been started but not completed. And would-be guardians get copies of these things not yet signed. Okay? And then a lot of times people get confused, understandably so. And they might say, hey, I have that, but it's not signed. Okay? But SDS does not accept those. And sometimes folks ask us to go retrieve documents because thinking, it's the state system, we should have access to those. We do not have access to those, so we do not retrieve them. If you don't have the full signed documents, then there's not proof of guardianship. Okay, so a person who's 18 years or older without the guardianship documents signed will need to sign their own documents. And there can be more than one signer. For example, the would-be guardian, they can sign too, right? The person can sign and anybody else they identify can sign. But when you're 18, it's the age of majority, you sign off on your own thing, and without those documents, then the person will sign. Question says, typically how many pages are in a complete guardianship document? It really depends. Usually probably about 10 pages. That's probably a fairly simple one. Okay. All right. Let's talk about power of attorney. So power of attorney is different because it's voluntary. So the person, age 18 and older, has delegated authority to another adult to act on their behalf. It's not a court appointment, okay? They've delegated a person to make health care and or other financial decisions if or when the person cannot. So the person is always in charge. That's one thing to know about power of attorney, right? No agent can act against their wishes. They're always in charge. So the person can decide to revoke or change power of attorney at any time. The powers can take effect immediately or upon a future event. An event means some kind of a determination that the person cannot act on their own behalf due to illness or disability. And this is called a springing power of attorney. The reason for this is because they are springing into action when they're needed. So I have included a power of attorney booklet, which has sample power of attorney forms in it, so you can understand more about that. I'm not going to go over that booklet here in this session, but it's in your handouts, and if you can't download it, do not worry. We're going to get you a copy of that by email so you can explore that. Okay? So what does SDS look for in power of attorney documents? A power of attorney document is where the applicant is giving the person, actually it's the applicant for waiver services that we need to see, that they're the person giving the power of attorney. Okay? The person carrying out the power of attorney might be called an agent, right, in the document. That person is listed on the SDS application form, and that's the same person as on the power of attorney document. Okay, so they're the same one as the power of attorney document. They're the agent, okay? It needs to have language that says the power of attorney can make healthcare, medical, or government decisions, okay? You can say those words exactly: healthcare, medical, or government decisions. Needs to be in effect and not expired. Some can be indefinite, and some have expiration dates. So if you get a document like that, make sure that you look for its dating to see if it's still current. Also, it needs to be notarized by a notary public with a visible notary public seal or stamp. Again, it needs to be the whole entire document. Didn't list that here, but if we get a partial document without the signature or without the stamp part, then that's not going to work, right? Or it can be signed and dated by two witnesses. Now, if the witness signatures have different dates than the person's signature, you might want to consider submitting a central intake report, because what it means is that they weren't really witnessing, it seems. Right? It seems they weren't really witnessing if they're on different dates. That's why. Okay? A limited power of attorney for personal care services is a document that may still be on our website, certainly used to be on our website. It is not accepted for waivers. Okay? So if that person has that document and they say, I have power of attorney document, and it says on it for personal care services, it is not accepted for waivers. They have to have a different one that meets these requirements. Okay, let's talk about durable power of attorney. What does SDS look for when it's durable power of attorney? You'll see language like this: except in the case of mental illness, my agent's authority becomes effective when my primary physician determines that I am unable to make my own health care decision unless I mark the following box. That's fine. It could be that kind of language or similar language, right? What they're talking about is the durable power of attorney and if there are any exceptions. So documents with a statement like this or similar need to be accompanied by an affidavit. So what is that? It's a physician's affidavit. There is no specific format. It can be a letter, and the letter needs to be signed by two physicians, and this requirement is located in Alaska statute. I'm not going to jump out and read the statute to you, but it is required, and that's why we do ask for it. Okay? So an affidavit is a physician's letter that confirms the information about durable power of attorney. Okay? And what else are we looking for here with durable power of attorney? It's a little bit of a special case. We do see them. For durable power of attorney, we'll typically see language that says things like this: this durable power of attorney shall take effect upon my disability or incapacity. This document shall become effective upon the date of my disability and shall not otherwise be affected by my disability. SDS is looking for the definition of disability, not just incapacity. Okay, so the physician's affidavit also must define their disability, and it can't say general incapacity. The affidavit doesn't have to have a specific format, and it must be signed, as we stated before. Okay, what is special to know about a springing power of attorney? Springing power of attorney has language that describes the event that springs them into action. The disability is defined, and it is accompanied by an affidavit. And it meets the same sort of compliance that we just talked about. The disability is defined, not just listed as incapacity. And it needs to be a letter or something in writing. An affidavit is usually a letter signed by two physicians. No format or templating for said letter, but it is required. Okay, I'm going to pause here and see if I've got any other comments or questions that I can answer here. There's a question about the guardianship or POA is approved by the PCA agency but not approved for the waiver. Yes, and thank you, training staff, for answering, and you might get an answer to your questions that you text in. That refers to the power of attorney for PCA, which is accepted for PCA but not for waiver. And so we're hoping to clarify these things. And then a nice tip here, thank you. Most banks and senior centers have a notary public on staff. Absolutely. So let's talk a little bit about legal representation of a minor. Just moving a few things around. Okay. Legal representation of a minor. What does SDS look for? Regarding power of attorney over a minor by a parent or guardian. A parent or guardian of a minor or minors can delegate power of attorney to someone over that minor child. A parent can delegate powers, parental responsibilities, in other words, to a responsible adult. Okay, so if a parent is not going to be available to make these decisions or provide for a child's needs, they can have somebody else do that for them. It doesn't affect anything really. They just delegate to somebody else their duties as a parent and decision making as a parent or guardian of a minor. So for these documents, it must be current and in effect. Again, they can have other, expiration dates that need to be identified and needs to be current and in effect. And I think my computer is getting a little bit updated here with your comments and things like that. So send them in, all good. The document must be notarized by a notary public with a visible notary public seal and stamp. Okay, a question, great question. Do you get the traditional guardianship documents when you adopt a minor child? Or do you get new guardianship documents when that minor experiencing disabilities turns 18? I'm going to do my best to answer, and I hope I'm understanding it right. And if I'm not, you can, just chat to me and let me know, what is still outstanding from my answer. If a person adopts a minor child, there are traditional adoption and guardianship documents, one and the same, that the person will get. When a minor who experiences disabilities turns 18, that minor is their own guardian unless a petition has been made to the court for guardianship for that person. Okay? So that starts with a petition is made for guardianship with the family court or probate court. And after that, if somebody wants to become guardian, usually they'll do that petitioning. There's just different ways it can go after that. I don't have I'm not prepared to teach that out right now today. But a person, when they turn 18, whether they have a disability or not, they will be their own guardian, and unless they have a guardianship applied by the court.
You covered it, Karen. There's nothing for me to add, so you got it.
Awesome. Okay. Nice reminder here. Notarized POAs do not expire when their certification expires. Lots of banks get this confused. Gotcha. Interesting. I can tell folks have lots of experience around this. Okay, so legal representation of a minor. SDS looks for, when it comes to Office of Children's Services custody documents, a document that is usually titled Findings and Order. It is issued following a permanency hearing. So you can imagine there's probably lots of other documents that come about before that. We are looking for the findings and order after a hearing is done. Okay, so it could be the same situation where folks are thinking they have a permanency document, yet they do not. Another title that we see is Emergency Petition for Adjudication of a Child. Or it could be called a Decree of Adoption. All of those are documents that mean OCS has created a final document regarding that child and their custody. Okay? So what's required? The whole and complete document, once again, all the pages, signed and dated by the Superior Court judge. So those are different forms that we might see around documentation for a minor. Okay, my next topic here was surrogate decision maker. A surrogate decision maker is a person who's through engagement with APS, Adult Protective Services, they are a person who can make decisions for somebody a temporary basis, right, as a surrogate. So this requires a letter from Adult Protective Services that says there's a surrogate decision maker. And the person who needs the decision maker is the applicant. When you're filling out the SDS document, I'm strictly talking about application and reapplication. Okay, that's when these documents come in. Okay, so the surrogate decision maker on the application is the same as identified in the APS letter. So it has to be that surrogate decision maker who's signing, things like that. Okay, so the APS letter needs to be signed, not a draft or something that was circulated to folks before all the decisions were made about who's going to do what. Okay, needs to be current and in effect, and the letter will tell the date of expiration for that surrogate decision maker to be done their decision making duties. All right, couple questions. Let me roll over to those real quick. Comment, I've ran into issues requesting records from medical providers if staff had changed at OCS and the child is just in custody while an investigation occurs. Tips for navigating with a medical provider. That's a real specific question. I think what you should do is bring those issues to us for during a care coordinator office hours. We can help unpack that case by case. I don't have any broad answer for you, but definitely reach out to either SDS training or your care coordinator liaison, CAT, and we'll help you figure that out. And then the question says, what documentation is needed for people who are their own guardians but have supported decision-making agreements? What about people who have legal guardianship and supported decision-making agreements? All right, I'm hoping to clarify that in the next few minutes. This is name change. If a person has a name change, legal name change document, the court document shows their name is legally changed. It must be complete, i.e. the whole document, all the pages, and it must be signed and dated by the Superior Court judge or magistrate. Okay, so I am at more helpful information, and I didn't forget about your question about supported decision making. Let me get to my next slide. If a person has out-of-state guardianship or POA, these are accepted. It needs to meet the criteria that we've already described. Same as what we've already said about out-of-state guardianship or POA. Okay, this is sort of my last slide. I don't have a separate slide about supported decision making. Okay. My best answer for you for supported decision-making agreements is that you submit the entire document and make sure that it's signed. If people have legal guardianship and supported decision-making, then you can submit both. And so supported decision-making may have attributes in it or pieces in it that have to do with waiver-related decisions. So usually, if a person has a guardian, they're making most of those healthcare decisions. But in supported decision-making, it's identified, that the person keeps control over certain decisions. So best thought is to submit that, make sure it's current and signed, make sure that it's still in effect, and if the person has other legal representation, then submit that document too. Okay. Question says, do we need anything if the guardian's name changes? They get married, and since being named the guardian, and have a new last name. Great question. My best answer is that the guardian, there's probably a form for that on the court website about a guardian name change, and that they should be encouraged to do that, to submit that change to the court. That is my best answer right now. I don't have a good answer for what SDS would do. Okay, we'd have to make sure that, of course, that's the person, but we'd have probably some kind of a record set on that. So, good question, though. I think I'll probably have to reach out to the court and ask that one. Thank you. Comment says, I've heard of supported decision-making being used to step down from guardianship. Well, supported decision-making is great. It's very advanced, and it helps people be in control of aspects of their life, because guardianship is also important, but at the end of the day, it also takes away people's rights. And so we want to preserve people's rights as much as possible. And that's where supported decision-making, comes in. And so we're happy to work with that, happy to help people be independent in decision-making as much as possible. Okay, a question about if a guardian wants to marry their ward, is that possible? Seems like a conflict of interest at minimum. Does the court do any research if the person has a guardian prior to issuing a marriage license? I don't have the resources to answer these questions. I think they're great questions during this session, okay? I don't have the resources for that. But I think you should come to one of our care coordinator office hours. And if you're facing a case like this, then we can help you unpack that. There certainly are resources out there for the public and about guardianship. There's a great website, especially for family guardians, called Asaga, and they can take these questions too. So they do a lot of Q&A for individuals and individual cases through Asaga. A lot of consultation and training as well. Okay, so yeah, you're welcome. And so this other information, you can find examples of interesting forms on the web. We've listed a power of attorney form over a minor by a parent, or guardian, I think. It's the wording. But you would go ahead and check it out at that website. I'm not going to go out there and jump to it, but it's in our materials if you want to at some point. Delegation of powers by a parent is available there as well. And so one of the big takeaways here, if documents don't appear valid or there's a concern about the existing or lack of guardianship, please consider submitting a central intake report. Okay? So the question about marriage and conflict of interest and things like that, You can always submit a central intake report, yes, a CIR. In this case, it's not technically in the list of critical incidents, but it is there. The central link is there for you so that you have a way to reach out and report a concern. Could be a concern about health and safety, could be a concern about guardianship documents, situations that affect health and safety or rights. It's not to be used for an emergency. It's not like 911, okay? So for immediate health and safety concerns that are immediate threats to health, life, property, all that stuff, that's for local emergency services, okay? But you want to report concerns about guardianship documents, things that you think might have been filled in wrong, relationships that you think are wrong, or questions that you think might impact the person, their ultimate health and safety and decision making and rights to act on their own behalf. Please submit a central intake report. Comment says some banks need to see the original guardianship or POA documents to take action. Photocopies are not accepted. There are a lot of sort of hoops and different rules around what entities want to see. Today we were hoping to convey to you what SDS is looking for and making it a little bit more clear regarding our review of documents that are legal representation for a person. And that is my last slide. Okay, so what I want to do is I want to ask you a few questions. Remember, we stated in the beginning that we had some questions that you could answer after this training. So let me actually do this. Let me pause my screen and get set up to share these questions with you. Please submit your questions and comments on this topic within the question area. We'll be happy to address them. And I'm just going to be frozen here for half a second while I set up my poll. I'm getting there, I promise. Okay, so here's a poll, and you can have fun with this. It's pretty easy. I'm going to launch it. Okay, question 1. What's the main difference between guardianship and power of attorney? Go ahead and click. Okay, I think everybody has answered, almost everybody. And you did a great job, because the main difference is guardianship is decided by the court, POA is voluntary. Okay? POA is not decided by the court, guardianship is not voluntary. It's the answer on the bottom. Okay, great work, everybody. I'm going to close that one. And I'm going to pick another one. Ready? What kinds of decisions are listed on a POA document? Healthcare, government, or education and lifestyle? Everybody vote. Okay, most of us have voted. And another awesome answer, healthcare and government is the correct answer, not education and lifestyle. Okay, good job. Okay, last one. Here goes. What can you do if you are in doubt about a person's legal document? Do you research the internet about it or make a central intake report? Which is best? What's the best answer? Everybody vote. Almost done. Some comments about it, the poll. Folks who seem to like the poll, so that's awesome. Some of us wouldn't do either one as the first choice. I'm just talking about the messaging from this particular presentation. I get you. That's the best answer. All right, great job. So the best answer on the screen here is make a central intake report. If you're in doubt, you can do that. Okay, I'm going to go ahead and close it. A question about the poll results. You know, I think I can share them. I just don't know how. They're less than 3% of us answered the choices that weren't the best answer. So we're just using it as engagement, something fun, and for a learning goal, of course, and help me understand whether you've met our learning goals today or not. And you've done a great job. Okay? One comment says, I would ask the person for more information. Sure, you could do that. Nothing against that. It's really not to say the entire spectrum of responses you could have when you have doubts. And we know it's always a more complicated story than just having doubts and making a report. So, all right. We're coming up to about 10 minutes till. That's fine. We do not have to spend the entire hour in the session. We can certainly leave a little bit early if you would like to. I want to go ahead and open our question area for all of you who would like to submit any last questions here before we close. Go for it. Okay. Comment says the general POA document put out by Alaska Legal Services on their form gives the option of this becomes effective immediately upon signature instead of waiting for, I think it says, an event, waiting for the person to become incapacitated. Okay, that's fine because they don't have to be springing. And they don't have to be a springing POA. They can be a POA. That's okay. I can delegate these decision-making capabilities to somebody, healthcare decisions to somebody, if I choose to do so. They don't have to be springing. It doesn't mean I give up my rights. I still make my own decisions. You know, I can revoke it at any point. A lot of people do this, you know, when they're aging and they feel that they want to choose a family member to make decisions for them, should they become unable to do so. And they can be a POA right away, but the person can still make their own decisions. I've seen POA forms offered by hospitals when someone's going through surgery or other interventions. These are the documents many of my family members have used. Yeah, I mean, I can see that that might be the case as long as they fit the criteria that we've described. And it's kind of a slippery topic because there can be so many different forms. So we're trying to give essential, you know, the core requirements here and make it somewhat consistent, make it a little bit easier that way. Okay. Well, like I stated in the beginning, if you haven't been able to download the handouts, no problem. We'll be sending those to you in an email. You'll be getting a separate email from the system that contains a link to a certificate that you can download. Occasionally, it's not you might not be able to do it. Okay, if that happens, give it some time. Make sure you're checking the correct email, the one that you registered by. Check your spam folder or junk mail, something like that. Maybe it goes to that. If you haven't found it anywhere, then shoot us an email at sdstraining@alaska.gov. All right. And we'll take care of you in terms of getting your credit for CEH. A question about how long does the guardianship process take? Somebody's turning 18 in the summer, and the family should petition the court. Gotcha. You know, it can take months. I think starting 3 months ahead would be a good idea. Now, since COVID, it really is depending on the offices being open and who's doing what and the staffing level. I wouldn't be surprised that it would take longer than that. Again, you know, it's not a horrible emergency in terms of getting waiver things done, because the person can still sign on their own behalf after they turn 18, and the would-be guardian can still sign. You know, we'll just need to have the person sign because they would be their own guardian on that magical day they turn 18. And that's okay too. So it does take quite a long time, probably longer than what I'm accustomed to, but my traditional answer would be like 3 months ahead. Very difficult to have guardianship documents come out the day the person turns 18. It's probably not going to happen. And the petitioner has to follow through. Yep. And you have to pay to start the petition. So they charge you some money when you go there and you petition. So. Mhm. Mhm. Folks are writing in comments. Hospital Advance Directives form has the first page list the name and contact info of the primary healthcare decision maker and the secondary. This person is then looked at as the POA for healthcare of that person. Okay. I've had one staff request question the form, saying it was advance directive. The form is on the Legal Services website. Okay. As case by case, I would say to work directly with the staffer. There might be other things that are happening that add to the question for that particular case. Which goes faster? Emergency guardianship order might be possible if somebody is having situations where they absolutely cannot act on their own behalf. It could be possible that emergency guardianship could happen faster. I really cannot speak for the courts and how fast things happen right now today. I'm just trying to give you some context over, you know, our typical situation is somebody's turning 18 and they experience intellectual developmental disability. You know, a petition has been made, but it's not final yet. That's usually what we see. Anything else, bring it to your staffer at SDS who's questioning, or you can bring it to SDS training or our care coordinator liaison who might be able to help or give you referral to another source. Okay, so that being said, I'll go ahead and close the session. Thanks so much for spending time with us here today and doing our poll. And we really appreciate you and everything that you do. Be safe out there, stay warm and cozy, and we'll see you at the next training. Bye for now.